The Supreme Court's 6-3 decision centered around Louisiana's congressional map, the court ruling that states cannot use race as the predominant factor in redistricting.
The Supreme Court today struck down the legality of drawing congressional districts to concentrate racial minorities so that they form a majority in the district and thus elect a racial minority to Congress.
The case revolves around Section 2 of the Voting Rights Act of 1965, a law created during the Civil Rights era to help protect minority representation.
Some states might use this as an additional reason to redraw their congressional districts for the midterm elections.
In California, Republican Assembly member David Tanguipa, who authored a lawsuit against Proposition 50, believes the ruling could strengthen their case.
This is actually what we challenged in the state of California and under the Supreme Court, was that race was actually used, which created a detriment to other racial groups.
Tanguipa says their lawsuit against Prop 50 is still active, saying the Supreme Court only declined to take up an emergency injunction, not the case itself.
If they believe that Prop 50 is dead, then they don't understand the judicial system.
But Democrats warn the ruling could have much larger consequences.
It's a complete gutting of the Voting Rights Act of 1965, Section 2 of it.
Johnson argues the decision could open the door for states to redraw districts in ways that dilute minority voting power.
They're going to be able to gerrymander or crack the districts in such a way now is that they can dilute black/Democratic votes in the South.
But while both sides agree the ruling is significant, Holyoke says California's maps may not be directly at risk.
Proposition 50 and its redistricting was not about minority-majority districts. It was about blatant partisanship.
Jason Toktagian, CBS 47 Eyewitness News.